Good evening, everyone. My name is Rick Lyons, and I'm one of the directors of the International Center on Human Rights and Drug Policy, which is based at the Human Rights Center at the University of Essex. And I'd like to welcome you all here today to Columbia, to what is the second of a series of international debates that we are organizing in universities around the world. Since the second, we had our first initial debate in Galway, Ireland last week, before we'll be moving on after New York to Pretoria, Jakarta, London, and finally in Bogota to finish off. And the purpose of these events is to provide a forum to explore some of the intersections between international drug control law and international human rights and international humanitarian law. Before we start, I'd really like to thank the Human Rights Institute here at Columbia for hosting us today. And I'd particularly like to thank Greta Mosen for doing all the work to help make sure this is an important event, and also Nancy Prudhomme, our project director here at the International Center on Human Rights and Drug Policy. Just a couple of words about our center. We were founded in 2009, and as I say, we're based at the Human Rights Center at the University of Essex, and our mandate is really to try to create a forum where we can use sort of mechanisms and analysis around international human rights law, international humanitarian law, to explore some of the conflicts and engagement between those areas of law and international drug control law. Probably most of you in this room are very well familiar with human rights law and humanitarian law. You're probably less familiar with international drug control law, which is codified as well under 3 international treaties which enjoy almost universal ratification. And certainly states' actions to meet their obligations under the 3 drug control treaties engage with issues of human rights in very many ways, whether those are around issues such as access to health, access to medicines, whether that gets into criminal justice, prisoners' rights, rights of due process, or as we're talking about today, issues around armed conflict and state violence and violence of drug cartels actually at a domestic level within countries. And we're very pleased today to be able to address that particular issue of whether or not drug-related violence, whether or not the law of armed conflict applies to drug-related violence, with an expert panel. I'd like to thank particularly the Open Society Foundation's Youth Initiative, who funds this particular series of debates, as well as, of course, our colleagues at the University of Essex. Just a bit about the format of the debate. We have a person speaking for and against the motion for about 10 minutes each, and then they'll each be able to respond to the initial presentations for about 5 minutes, and then we'll get into a bit of facilitated discussion, and of course very much encourage contributions and questions from the audience. I'd like to pass over in a second to our distinguished moderator, Mr. Gabor Rona, who is the International Legal Director of Human Rights First, where he advises the organization on questions of international law and also coordinates international human rights litigation. He represents the organization and works with governments, intergovernmental and non-governmental organizations, as well as the media on matters of international human rights law and international humanitarian law. Prior to coming to Human Rights First, Gabor was legal advisor in the legal division of the International Committee of the Red Cross in Geneva, where he focused on the application of international humanitarian law and human rights law in the context of counterterrorism policies and practices. He also represented Committee of the Red Cross in connection with the establishment of international and other criminal tribunals in court, including the International Criminal Court. And he's also taught international humanitarian law and international criminal law at many academic institutions. And before turning over to him to host the event and to introduce our 2 debaters, I'd just like to maybe ask the question, first of all, to get a bit of a feel for the room at the start of the event. How many people believe that the law of international armed conflict does apply to drug-related violence? Maybe just raise your hands. Okay, how many people think that it doesn't apply? And how many don't know? Okay, well, there's a pool of people there that are just right for you to try to convince. So thank you very much, and I'm pleased to turn it over to Gabor to host tonight's event. Thank you.
Thank you very much, Rick. And I also want to thank the Center at Essex and Columbia and OSF for hosting this event and for inviting me to moderate. We do have two of my favorite people to talk about these issues, and I know them well. It will be civil, so I think we can use human rights law to referee between the two of them, not IHL. And but I first want to say a word or two about why this is a useful topic. It's useful for the obvious reasons that there is quite a bit of violence on all sides of the equation in connection with drug interdiction. So the question naturally arises whether or not IHL applies to these kinds of situations. But in addition to having a war on drugs, we've got wars on poverty. We have now a war against women. We have a war against Christmas. Some of you who may have watched some Fox News may know about that. Obviously, we have a war against Al Qaeda. We have wars against terror, and which are not necessarily the same thing. And so questions naturally arise not just about the issue of drugs, but also about some of these other issues. When and where do the laws of armed conflict apply? And it arises, obviously, more significantly when we have situations of violence in these wars. And the answer has important consequences to a number of areas, not only when and how force can be used, but also to questions of detention powers, rights of detainees to challenge their detention, to questions of detainee treatment, and to what processes do if somebody's put on trial in connection with these kinds of situations. So we'll get a lot more elucidation on all of these topics from our debaters. And let me give you a short bio on both of them. Professor Sassoli, who's on my right, is a professor of international law and director of the Department of International Law and International Organizations at the University of Geneva. He's also an associate professor at the Université de Québec in Montreal and the University de Laval in Canada. He also chairs the board of one of my favorite NGOs of all time, Geneva Call, which is an organization you should really know something about and look up if you don't know what they do. He's worked in the past for the ICRC, which was also my previous employer. He's worked for them both at headquarters and in the field in Jordan, Syria, former Yugoslavia, and during a sabbatical in 2001, he joined the ICRC as a legal advisor to its delegation in Islamabad. Professor Sassoli has published very extensively on IHL, human rights, international criminal law, on the sources of international law, and on the responsibility of state and non-state actors, issues that are very germane to today's debate. Dr. Noam Lubell, on my left, is a reader in the School of Law at the University of Essex. I always thought that was an unfair kind of title. He's much more than a reader.
In the UK, it's a good one.
Yeah, I guess. Right.
Means something else.
So, for example, he's taught international human rights law and on the law of armed conflict in a number of academic institutions, including National University of Ireland, Oxford, in Israel, as well as in the U.S. In addition to his academic work, during the last 15 years, Dr. Lubell has worked for various human rights organizations working on conflict, including within the Israeli-Palestinian sphere, has provided consultancies and training for international bodies, government bodies, and also the BBC. And he was a member of the Executive Committee of Amnesty International in Ireland. He's authored numerous books and articles in this field, and is currently the rapporteur of the International Law Association's Committee on the Use of Force. With that, let's go. Marco?
I don't remember who should. Yeah. Perhaps, good evening and welcome.
But yes, we had our preliminaries, don't we?
Yeah, we have us lawyers always preliminaries, but obviously I see quite a number of faces of IHL specialists here. Nevertheless, I thought that as this will attract quite a number of drug policy specialists to give you some, I hope, neutral introduction into international humanitarian law. So international humanitarian law is a branch of international law applying to armed conflict and trying to protect, not everyone, those who do not or no longer directly participate in hostilities, and to reduce the violence to what is unfortunately necessary in an armed conflict to overcome the enemy. International humanitarian law applies always to both parties to an armed conflict in the same way, independently of who is right and who is wrong, independently of the causes for which the parties fight. International humanitarian law does not justify armed conflict. Obviously, ideally, it would never apply. It was born as the law of international armed conflict. Born is exaggerated. The modern humanitarian law was born as law of international armed conflicts. International armed conflicts are armed conflicts between states, but today it also applies to non-international armed conflicts, but not every violence between a state and a non-state actor, or between different non-state actors, constitutes an armed conflict. There is a need of a minimum of intensity of violence and a minimum of organization of the non-state actor. And international humanitarian law of non-international armed conflicts, which is interesting here for us tonight, is in the treaty texts much less developed than the law of international armed conflicts. The law of international armed conflicts foresees things which are outrageous. You may deliberately kill someone without even trying to arrest that person, a combatant on the battlefield in an international armed conflict. And you may detain a person without any judicial procedure for an indefinite period, a prisoner of war in an international armed conflict. And there is controversy how far, by analogy or through customary law, so-called customary law, the same rules also apply to non-international armed conflicts. Another controversy is whether the law of armed conflict, international humanitarian law, simply prohibits certain conduct, or whether it also contains authorization of certain conduct. I explain myself. The international humanitarian law doesn't prohibit to detain prisoners of war. Is this a sufficient legal basis to detain them, or do we need, in addition, legislation? No state in the world has legislation in this sense. You may understand that for non-international armed conflicts, on the so-called war against Al-Qaeda and so on, this is a tricky issue, whether the laws of war are a sufficient legal basis for detaining, for killing. Well, in the last week you have heard some things here in the US about this. I should give some explanation about the relationship between international human rights law and humanitarian law. You certainly understand that humanitarian law is less humanitarian than human rights law, because under human rights law you may not deliberately kill someone without trying to arrest that person, and you may not detain a person without any judicial control. Human rights law, this is today generally accepted, applies in armed conflicts. There is controversy, but which is not important for us tonight, whether it applies extraterritorially. Where there is controversy is what's the relationship between the two when both apply, which is always the case in a non-international armed conflict. And the traditional answer to this is the so-called lex specialis principle. But this principle, what it means is controversial. Some people, and this is mainly the US theory, is that humanitarian law always prevails. Another theory is that humanitarian law at least prevails when there is a specific rule on an issue. Another theory, that's more the human rights people, would say the more protective rule prevails when there are rules of both which apply to a certain situation. Or finally, the more specific rule, taking into account each situation, one has to determine which is the more precise, more specific rule, taking into account also that the overall systemic purposes of the legal order. Now, all this sounds theoretical. It has very decisive practical consequences, because if in a non-international armed conflict human rights law prevails on issues which are not dealt with in the text of the conventions, then you may not kill an enemy fighter except according to the law enforcement mode. While if humanitarian law prevails, because we make an analogy, and this is a tendency today, with international armed conflict, or we pretend that this is customary law, then such a person may be killed. So it's a question of life and death, or death, which of the two prevails, in particular in a non-international armed conflict, because in international armed conflict somehow it's not really controversial that on the battlefield it's humanitarian law which prevails for the question when the soldier of one army may kill the soldier of another army. I hope this was useful as an introduction.
Thank you, Marco. So now we have an introductory framework into these legal frameworks: humanitarian law, human rights law, and the differences between them, the principles that apply to each one. And also, before we get into the meat of the debate, Noam's going to say a few words about the background situation concerning Mexico and the drug problem in particular.
So this is just, again, in terms of background, the initial idea of the debate was to talk about drug-related violence more generally, and whether law of armed conflict can never be applicable. But I think for both of us, the more we sort of started thinking about it and preparing what we want to say, we found ourselves looking again and again at Mexico specifically. So I just wanted to explain why you're going to hear more about Mexico than maybe about other situations, though you will hear about others as well. And there's probably two good reasons for this. The first is you've got the level of publicized drug-related violence in Mexico is comparatively high. There are different estimates. It varies from, in terms of the deaths in the last 6 to 7 years, anything from 40,000 to 70,000 people have been killed in drug-related violence. There's been a lot of violence between the state and between criminal organizations, with police and soldiers being killed, public officials such as politicians and mayors being assassinated, large numbers of civilians amongst the dead, violence that's caused the displacement of tens of thousands, some say over 100,000 people have been displaced by the violence. So this level of violence makes one think of, in terms of what we're seeing, something that might fit in or not, as we're going to discuss, the paradigm of armed conflict. And there's been a lot of talk of this war on drugs, and Gabor was talking about sort of war on. As a war on drugs, there's been talk of it not just as a rhetorical war, but as possibly some have started to argue as a bona fide armed conflict. And so you see this in all sorts of ways. We've seen a letter being sent by a group of lawyers, a letter sent to the ICC asking the International Criminal Court to begin an investigation into war crimes in Mexico. Okay, so that's one of the legal implications that you would see from this. So this debate is out there. And the second reason I'd say that Mexico is a good case study for this particular question we're debating today is that some of the other countries in which you have drug-related violence also have armed conflicts that are not so much in dispute. There isn't a big argument that there's been an armed conflict in Colombia, for example, or in Afghanistan. Okay, so two other countries where we have drug-related violence, but it's clearer that there's an armed conflict there, whereas in Mexico there isn't sort of a separate armed conflict that creates a need to separate between the armed conflict we already know exists and the drug-related violence. Over there, we're looking straight at the drug-related violence and we're asking, is this in and of itself an armed conflict? So these are the reasons that Mexico is probably a good case study for this, but that's not to say, and I want to stress, that this question is just about Mexico. You'll hear about other countries as well, and at the end of the day, the implications of what we're debating here are relevant for many other situations, both current and, unfortunately, probably future situations as well.
Thank you, Noam. So now we'll get into the heart of the debate, and the format will be basically this. Marco will start first to argue the case for application of the laws of armed conflict. Then he'll have 10 minutes. Then Noam will follow with the argument con, and then they'll be back and forth for about 5 minutes between the two, and then we'll open it up for discussion to the audience. So, Marco.
Thank you very much. Well, I'm one of these old-fashioned kinds of lawyers who, when they have a problem, they don't first think, what result do I want? But this may be my civil law training. I look into the law, including the jurisprudence, scholarly writings, about what a concept means. So the question is, what does the concept armed conflict mean? But I have to add, obviously the consequences, especially when it goes to a concept, are important in interpreting a concept, because concepts in international law have not been adopted as a religious dogma, but because they have certain legal consequences. And if the legal consequences were, but they are not, and I will try to convince you, unreasonable calling it an armed conflict, we should think, even if it clearly falls, as it does, under the criteria of an armed conflict, we should think this is unreasonable. There must be an exception for such situations. But I'm convinced this is not the case. So, what is an armed conflict? I think the International Criminal Tribunal for the former Yugoslavia and the Tadic case has started to define a non-international armed conflict as protracted violence. Well, unfortunately for Mexico, this violence is quite protracted. Then in the Haradinaj case, they have tried to define more precisely the two criteria of intensity and organization. Indicative factors, I quote from the Haradinaj case, paragraph 49, that was about Kosovo, relevant for assessing the intensity criterion, none of which are in themselves essential to establish that criterion, are the following: the number, duration, and intensity of individual confrontations. Well, unfortunately for Mexico, there are all the time confrontations. They are very intense. The government has, at least under Calderon, clearly adopted a military, a counterinsurgency strategy. We have more people who die every year from armed violence in Mexico than in Afghanistan. The type of weapons and other military equipment used, well, there are anti-tank guns, heavy machine guns, landmines used by the armed wings of these drug cartels. And I spoke recently with a Mexican Marines officer who told me that in some of these fightings they are simply outgunned by the drug cartels, they have a better equipment than the Mexican Marines, who have an important role in that. The number and caliber of munition fired, so 50 caliber rifles, anti-tank 66 millimeter rockets are used. The number of persons and type of forces partaking in the fighting, 60,000 soldiers are deployed in Mexico. The number of casualties, 14,000 dead in 3 years. The extent of material destruction, indeed, that's rather limited. It's mainly against persons in Mexico. And the number of civilians fleeing combat zones, according to some numbers I read in, I think, serious sources, 1.6 million people have been displaced over 6 years, which doesn't mean that they are still displaced in Mexico. And for instance, in Ciudad Juarez, 1/10 of the population, 200,000 people, have at a certain time been displaced. So I think the intensity criterion is not really the problem. Let's come to the organization. The International Criminal Tribunal says the indicative factors include existence of a command structure and disciplinary rules and mechanism within the group. It is clear that in the group they have certain rules, not humanitarian rules, but they enforce these rules. I should clarify that obviously we cannot take all the drug cartels, as they also fight a lot against each other, as one armed group. These are several armed groups, and I can certainly conceive that some of these armed groups are not sufficiently organized, but some are clearly like those who fight for the Sinaloa cartel or the Nuevos Zetas. The existence of a headquarters, well, this is perhaps more in a figurative sense. The fact that the groups controls a certain territory, which is not necessary for Article 3 common applying, and Mexico is not a party to Protocol 2. There are roadblocks. The ability of the group to gain access to weapons, well, no problem. Other military equipment, recruits and military training. Its ability to plan, coordinate and carry out military operations, including troop movements and logistics. They recruit. For instance, the Zetas consist in good part of former members of the Guatemalan armed forces and some defectors from the Mexican armed forces. Its ability to define a unified military strategy and use military tactics, indeed, it is clearly a question of military tactics. So I would say, especially taking into account that the Tribunal for the former Yugoslavia in the Milosevic case had said in 1997, when there were 20 Serb soldiers killed by Kosovar forces, that this is sufficient as intensity, that this is sufficient. Now, the only way how to escape to the classification as an armed conflict would be that there is an additional condition, which is a political objective. The International Criminal Tribunal for the former Yugoslavia in the Limay case said the determination of the existence of an armed conflict is based solely on two criteria: the intensity of the conflict and organization of parties. The purpose of the armed forces to engage in acts of violence or also achieve some further objective is therefore irrelevant. Obviously, the tribunal could be wrong. Now, if we want to define, and this is the problem, what is a political objective, we could look into international refugee law and international criminal law, the political offense exception in the extradition treaties. This would be something like to overthrow or to change the government in a country. That's a political objective. But there's also a proportionality requirement that the acts must be proportionate to this aim. And now most armed groups acts are not proportionate to these aims, but fortunately we don't say because of this that this is not a political objective. And even independently of that, please tell me, Al-Qaeda, what's the political, what government do they want to overthrow? Or the Lord Resistance Army in Uganda? Or the RUF in Sierra Leone? What's their political objective? Should we then say, no, this is not either an armed conflict? And this is an important concern for me in this entire debate, that if we admit that political objective is one of the conditions, then obviously the government of Colombia will rightly say, the FARC, they don't have a political objective. These are simply drug dealers. And then we have, in every armed conflict, an additional discussion to make the law applicable, that the government will deny that the armed group has a political objective. I think we have to stick to the objective criteria, to the facts, and not to objectives to define what is an armed conflict. And I would add, I don't understand why should we have this as a criterion. In my view, this is somehow a left-wing 1970s idealism. Che Guevara, he had a political objective, and this is noble, and therefore we want to have the law of armed conflict applicable. But you know, if your objective is like of the Bosnian Serbs group, simply to ethnically cleanse the Muslims, in my view, this is not more noble than to deal with drugs, I must say. So I don't understand why we should use it. Just a last point, the great advantage of international humanitarian law applicable is that then we have two parties, and this means that the other party is also bound by humanitarian law, and you can try to engage them. Now you will say, the drug cartels will never listen to engagement. Well, I have to quote the UN Secretary General, who in his report on the protection of the civilian population wrote that while engagement with non-state armed groups will not always result in improved protection, the absence of engagement will almost certainly mean more, not fewer, civilian casualties in current conflicts. And I should clarify, for those of you who are concerned that this gives them, to admit that it's an armed conflict gives them legitimacy, Article 3 common to the Geneva Conventions, the last paragraph says, the application of the preceding provisions shall not affect the legal status of the parties to the conflict. And they remain criminal, and the Mexican government has the right and even the obligation to try to win this conflict, but I don't think they will win it by saying it's not an armed conflict. And at least President Calderon always called it an armed conflict. I'm looking forward to hear why it should not be an armed conflict.
Thank you, Marco. The next 10 minutes or so we will give to Noam to convince you of the contrary, that the law of armed conflict is not applicable to drug-related violence, and then each speaker will have a 5-minute opportunity to rebut his opponent. Noam?
Thanks, Gabor. All right, so my task here is to present the case against the applicability of the law of armed conflict to drug-related violence, and I think there are very strong grounds to conclude that this should not be considered an armed conflict. And right at the beginning, Marco explained criteria, intensity of violence, the organizational requirements, and the debate over whether motivation or purpose should matter or not. And I think that examination of all three of these, on each one of them on their own, but certainly all three of them together, one by one, will show why the law of armed conflict should not apply to drug-related violence. And I'll start with the question of motivation, because that perhaps is the one that's most debatable. Now, I'm not going to dispute that the formal requirements that you find in the texts for the classification of an armed conflict don't mention the motivation of parties. And in that sense, all the interpretations, whether by the criminal tribunals or learned academics, they are correct. The law doesn't say anything about motivation. But I don't think that means that it's irrelevant. First of all, let's be honest. The reason it wasn't included in the texts isn't because the drafters of the Geneva Conventions wanted to exclude organized crime from the sphere of armed conflict, is because it was so obvious to them that it's not there in the first place. And you can look at some of the discussions and debates that occurred back then. Nobody was seriously considering organized crime as armed conflict, so they didn't put it in there. They didn't think that we need to put it in there. They didn't imagine that one day we're going to be sitting here in Columbia University debating what we're debating now. It's not meant to be so, and this is reflected in the position of states who said so at the time. You look at most states today, that even when they're dealing with high levels of violence in this context, they still largely do it through law enforcement framework. So state practice demonstrates that it's excluded as well. And the whole concept of non-international armed conflict was developed around civil wars, large-scale civil wars, not around organized crime. Now, the ICRC traditionally wanted to widen the net of international humanitarian law. And we saw sort of over the years more and more attempts to say, maybe we should call this an armed conflict as well, and that. And this was for a noble cause. This was because they wanted to extend the protection of international humanitarian law to as many situations as possible. As I said, a noble and worthy cause. But this was done without thinking as much of the existence of international human rights law, which wasn't as strong initially in the early years following the Geneva Conventions. And I would say we don't need to try and call more things an armed conflict so we can have protections from human rights law, because nowadays we have a well-established international regulatory framework which is called international human rights law and can provide these protections. So there's no need on that count. Now, I'd agree that it's difficult to ascertain what is the motive of a group. And are we going to get into questions of, the government will say, they don't have a political motive, they're just criminals. But what I'm proposing isn't that we should have a pure political motive in order for it to be an armed conflict, but rather that if we have a pure criminal motive, it's excluded. And in other words, the fact that a group in an armed conflict which has political aims also has criminal aims, I'm not saying that should exclude them, but the other way round. And note, I'm not saying it's up to the government to say, they're just criminals, but if the group themselves do not claim to have any political motivations, so if the group itself essentially excludes itself from the realm of political conflict, those types of situations, I would argue, should not fall within the international legal paradigm of armed conflict. So for these reasons, I could say I'll rest my case here, and I won't even go into the threshold of violence and organizational. I think that's enough to win the case. So I could be cheeky and I'll say I won't use up all of my 10 minutes. I'll stop here. That's it. It just shouldn't be an armed conflict. But just in case some of you aren't convinced, I'll move on to the questions of the organizational threshold and the intensity of the violence. So on the organizational side, we know, and we've discussed this, you need a certain level of organization. Right? The fact that you just call something a war doesn't make it a war. Otherwise, what would the war on poverty be? War against the poor? The war against the IMF? That's just rhetoric. So we need to see certain things. And organizational structure of the parties to the conflict is one of them. And a lot's been made of the organizational structure of the drug cartels. A high level of organization, impressive level of sophistication in their activities. But that doesn't necessarily mean that they're organized in the manner that we require for them to be a party to an armed conflict. And organized in the context of crime is very different to organized in the context of conflict. And just to give you a little understanding of the difference, the UN Convention Against Transnational Organized Crime defines an organized criminal group as a structured group of 3 or more persons who aim to gain financial benefit through serious crime. Now, obviously, that is not what we require for an armed conflict. We require a lot more than 3 people who have a criminal motive in order to say that you have an organized party to a conflict. And I won't repeat. Marco discussed some of the what we need in terms of structure to call an armed conflict, command structure, internal discipline. That's very important to be to be able to enforce the laws. Right? The group has to show that they're capable of actually enforcing the laws and having a hierarchical structure. And what I would argue here is that the drug cartels do not meet that organizational requirement. Most of these organizations are a network that run from people growing coca plants, those working in the methamphetamine labs, the processing factories, transportation, accountants, lawyers, all of that, corrupt politicians. They're all part of these organizations. Are they all members of the group? Do they all fit within this organizational structure that we're talking about? Generally speaking, the business side of it all tends to be highly organized. The violence side is less so. And if you look at it closely, you'll find that it probably doesn't really fit what we talk about organization when we talk about the criteria for being an organized party to a conflict. One of the biggest problems is who is the party to the conflict. On one side, we have the Mexican government, but who's on the other side? There used to be, years ago, it was the Guadalajara organization was considered to be sort of the main organized crime group, if again, using the Mexican example, but there's been continuous fragmentation amongst these groups. Some today will still speak of the 7 main cartels, but actually most assessments show that there are more than 100 different groups operating on the ground. And even the larger ones are not monolithic units. They don't belong to a single organizational structure. They operate usually as a franchise, a syndicate model, and you have percentages of profits distributed amongst different groups. Even the most organized of them all, the Zetas, have semi-autonomous cells, which again means you don't really have that hierarchical structure. You've got lots of different groups. One group controls the border, another controls specific trafficking routes, another one controls distribution in a certain area, and amongst all of these you've got constant shifting alliances between them and rivalries between the groups. So that means we don't have the requisite military-style structure. Okay? When you have a network of franchised groups, you don't have a hierarchy of discipline. You don't have the possibility of the leader of one group can't enforce discipline within an allied group that don't actually work for this leader. And that's essential for the laws of armed conflict, to have that hierarchy and discipline, and you don't have this in sort of network of shifting alliances and rivalries. And if I turn now just finally to the question of the threshold of violence, whether it's met, because like I said, I don't think we met the organizational threshold, but even the violence, initially we hear these numbers, and the numbers are quite alarming. That's clear. I've said maybe 60,000 or more, hundreds of thousands possibly displaced, and I'm not trivializing the tragedy of the numbers in that sense, but we also know that high numbers of casualties doesn't automatically mean armed conflict. You have high numbers of casualties in natural disasters, earthquakes, tsunamis. I mean, we don't see 100,000 people died, there's been an armed conflict. Right? You need to dig a little deeper. Now, obviously, deliberate crime is not the same as a tsunami, but even high numbers of crime victims doesn't mean armed conflict. In the US, for example, there are around 15,000 homicides every year. So if you add up the homicides in the US, that's more people killed than people killed by crime in Mexico in the same period, of the same years. You've got, in 6 years there, you've got 90,000 people killed in the US. We're not saying crime in the US is an armed conflict. So the numbers aren't enough. So the answer to that, of course, Marco can then say, well, it's different. In Mexico, it's not just lots of different homicides. It's very clear all of this is part of the violence of particular groups. But note, groups in the plural. Okay. So when you're trying to show that the intensity of violence has been reached, you need to show that that violence is between parties to the conflict. So you need to show that between the state and this group, you've had that level of violence. And as I've just shown, within the so-called drug wars, you have all of these different groups, and they all operate separately. In fact, half of them are fighting each other most of the time. So you cannot just take all of the violence caused by all of them and lump it all together and say this is evidence of an armed conflict. It's similar to the problem we've had with the so-called war on terror, where all of the violence by anyone labeled a terrorist all over the world is all lumped together and then said, look how much violence is going on, it's a war. But you can't just add it all together. if they are separate groups, if they're not part of the same structure, then you have to actually look at each one of them separately. And if you look at each one of them separately, I'd say I'm not so certain that we've crossed the threshold of violence. And most of the violence that we see is between these groups. It's not even with the group and the state. So taking all of that into account, I'd say it becomes highly questionable whether even the high number of casualties from all of the drug-related violence can actually be added up to be considered part of an armed conflict. So, to conclude the initial presentation, I'd say that the law of armed conflict isn't applicable to drug-related violence on all three counts. The threshold of violence cannot be added up in such a way that legitimately shows a conflict between a party and the state. Secondly, as organized as they may be in some of their activities, they don't actually meet the level of organization and the type of hierarchical structure that we require to be a party to a conflict. And finally, that this body of law was never intended to regulate the relationship between the states and pure criminal organizations like drug cartels.
Thank you, Noam. Marco, 5 minutes.
Thank you. Well, it was not meant for armed conflicts, for such situations. This may be true, but the U.S. Constitution was not either meant for nuclear power stations, but it applies to nuclear power stations. It may be that in 1949 the idea was civil wars like the Spanish Civil War, but fortunately today it is uncontroversial that even situations like the Sendero Luminoso in Peru or the RUF in Sierra Leone, the RUF, its only objective was to loot natural resources, and we have today all around the world more and more armed groups, in particular in Africa, which simply you cannot possibly say that the leader has another objective than to put as much money as possible into a bank in Switzerland. And is this a political objective? Should we then give a prize to hypocrisy to say at least they must claim they have a political objective? Okay, if you tell that to Mexican groups, they will even tell you that they have a political objective. I agree that we have to distinguish the parties and the armed group of the parties. I don't say that the drug dealers become combatants. It's only the fighters for the drug dealers, but they have, just as Hezbollah or Hamas, they have their military wing, and these people are organized in a military way, at least for some of these groups. And obviously I don't claim for 3 people, but in Mexico, and not only in Mexico, there are situations where it's a sufficient number of people who are militarily organized and are fighting. Now, the argument to say it's a network, it's not a military hierarchy, obviously I would prefer armed groups which have a hierarchical structure. But this is simply today often no longer the case. Even for the Taliban, if you look into experts, they will give you the information that precisely because the government against which they fight, including the US government, try to decapitate them, it consists largely of fragmented little groups. And so Noam would say, in Afghanistan there is no armed conflict. And inevitably in Somalia, at least the UN Security Council has always considered that there is an armed conflict, but there are also shifting hierarchies and sympathies and so on. Now, I'm very sensitive to the problem, and I must say it was my greatest problem for defending this position. The argument human rights law is better, but this is either a misunderstanding of the relationship between humanitarian law and human rights law, or simply an idealization of a situation, and unrealistic rules don't protect anyone. Let's take it about targeting. First, I would say it's not so clear that in a non-international armed conflict you may target someone just because he or she is a member of the group. If any, it must be of the armed wing of the group. And even if we accept that, so it would not be every drug dealer may be killed, but it would be the Nuevos Zetas, the members of the Nuevos Zetas may be targeted as enemy fighters. And this is what actually happens. Then, if we look into the detention issue, again, it would not be that every drug dealer or every member of a cartel, but those who actually fight for a group could be detained without being brought before a tribunal, if we make this analogy with international armed conflicts, because nowhere in humanitarian law of non-international armed conflict it is clarified who may be detained in a non-international armed conflict, and you could well argue that this is an issue. Someone who is detained is under the control of the government. This is an issue dealt with by international human rights law. So, human rights law remains applicable, but human rights law does not bind the enemy, the armed group. And if we want to try to engage them and want to not ignore the fact that there is an armed conflict, but try to protect the victims of this armed conflict, we have to admit that there is an armed conflict, and for instance, rules on the treatment of the wounded and sick. I'm not so convinced that these groups and those who fight for these groups could not be brought to respect such rules. Thank you.
Thank you, Marco. Noam?
Okay. So the rebuttal to the rebuttal.
Mm-hmm.
Well, first of all, I'll say this, Marco. I agree with your initial opening statement that what we need to do is look at the law. It's just that I look at the law and I see something else. Now, this question of the motive, which has been something which we've come back to, both of us, time and again. Clearly, a lot of groups, you mentioned the RUF in Sierra Leone, have criminal motives. They want to control the diamond mines and so on. But even in these situations, the RUF also did want to overthrow the government. And tried and took over, taking over Freetown and Sierra Leone. This is not the same as what's happening with the drug cartels, and I don't think that's a correct comparison. And this precisely goes back to what I was saying earlier: the difference between having groups that have a mixture of political motives and criminal, and trying to have criminal gain, as opposed to what's happening with most of the drug-related violence, where you have criminal gangs that operate within a state structure. Rather than trying to overthrow it, they're trying to take advantage of it. They'll have some corrupt politicians in their pockets, but they're not trying to change and take over the government. They're trying to get a financial gain within the system. And I think that is a big difference. And I think that's the difference also between this and between some of the examples that you gave, such as the RUF in Sierra Leone or the Lord's Resistance Army in Uganda and others. So I think it is possible to make that distinction between these groups and other groups, and for those reasons to exclude some of them from the ambit of armed conflict. As to some of the other points that were made, well, you mentioned the use of weapons, the heavy weapons, and the fact that they sometimes even have better weapons than the states, and we know also the large number of soldiers that are deployed. But that in itself, again, is not enough to call something an armed conflict, and we know that from all sorts of areas. And I can give you one other comparison here is piracy. Okay? Combating piracy is done often by, or almost always done by naval forces. It's done through the military. They use they'll use battleships, they'll use missiles, and the pirates themselves will often have heavy weapons, but it's not considered armed conflict, piracy. the framework for piracy, as you find in the law of the sea, is a law enforcement type of operation, which happens to be conducted by the Navy because they are the most appropriate body to be able to do this, but it's still not considered armed conflict. So just by saying, oh, look at all the weapons, look at the soldiers, that's not enough to call something a war. As for the level of organization, I won't belabor the point and say what I said earlier, but I simply do not think that structure is there. Being organized for the sake of running a criminal enterprise is not the same as the organization we need for armed conflict. The key for armed conflict, and if you go back to the same cases that Marco, that you cited earlier from the Tribunal for former Yugoslavia, what they are looking at time and time again, the most important thing that they want to find is a minimum organizational structure that enables the ability to enforce the laws, to have a certain level of discipline and to adhere to the rules, and you do not have that in this type of network of organizations that carry out different functions, and you cannot enforce discipline sideways within these. You might have each single group in one area might have that, but then we don't have a conflict if you do it that way, because you can't add up all of their violence together. You have to look at each one separately. And that's where, as I said earlier, there is a link between the organizational structure and the threshold of violence. And even if, and this is the last point I'll make for now, even if we say that, okay, well, but maybe just that group over there, say the Zetas, who are amongst the most organized, and it's here you have former military people who are running this group. The Zetas, they are organized. They're really organized. They've got that structure. They've got that discipline. Even if perhaps you could point out one group that's there, well, first of all, we'd have the problem, as I said, with can we say that the violence only from the Zetas is enough to reach the threshold of armed conflict? And even if it was, you're going to end up with something completely unworkable, where you're telling the military, okay, if you're firing on the Zetas, you might be able to use the law of armed conflict paradigm, but all the rest you can't. It's simply not workable on the ground. You can't do that. So I just think it both in terms of the practicalities, but more importantly the law. I'll stand by what I argued earlier.
Thank you, Noam. So now we get to the Academy Award portion of the program, and I'll remind you, Rick, correct me if I'm wrong, but my count earlier was that there was the smallest minority for the position that IHL does apply in these situations. A slightly larger number said no, it doesn't, and the vast majority of you shrugged your shoulders in the initial vote. So let's see if anything has changed. Did I get that about right?
Yeah. I don't know if you wanted to give people a chance to ask a few questions first, or questions after.
I thought we were going to vote first, but however you want to do it.
No, let's vote. Let's
vote. Okay. So I won't attribute names of my colleagues here to these two positions, but what is the vote for applying international humanitarian law to the drug situation in Mexico? Well, the numbers have increased substantially.
Did you count?
Let's put them up again.
Yeah. No, that's
1, 2, 3, 4.
The laws of war.
Yes, the laws of armed conflict. 1, 2, 3, 4, 5, 6, 7, 8. I got 8? Okay. And how many to the contrary? Quite a few more.
1, 2, 3, 4, 5. It's about 14.
14. Okay, so I'll know if you're double voting. How many still have no opinion? 2.
Yeah.
Okay, so something really did happen as a result of this debate. What we'll do now is abandon the debate format, and you will find out whether or not our debaters really believed what they were arguing, or are they just really good lawyers. And let me start out some of the conversation with what it appears to me was perhaps the most salient point of argument here, and that was perhaps the issue of political motive. And I'll start that with a question to you, Noam. if political motive is a requisite element to establish the application of the laws of armed conflict, IHL, laws of war, whatever we call it, does that violate the principle that what we call jus ad bellum is separate and has no effect on jus in bello? And could you also explain what the hell I'm talking about?
There's for those who aren't familiar then with that, so just the background here, there is a traditional separation between what we call the jus ad bellum, the laws on the resort to force, when you start a war, who started, who's the aggressor, was it self-defense or not, and the jus in bello, the laws that apply during an armed conflict. And it's not supposed to make any difference as to our views on the jus ad bellum, as to, for example, was it an act of aggression or not. Regardless of that, you apply the jus in bello in the same way. Now, I would argue that that's not really a consideration here, first of all because the rules on the jus ad bellum relate to international armed conflict. We're talking about a non-international armed conflict situation here, so we don't actually debate the ad bellum at all. For the question before us now, we're looking at a non-international armed conflict. Non-international armed conflict operates very, very differently in that sense. What we need is to look at the classification of a situation. Does it meet the required classification? And here we come back to the earlier point. Should that classification include looking at motivation or not? To my mind, it should. Again, I concede that there's nothing in the text that says so, but I think if you look at the object and purpose of the law, which is a legitimate way of interpreting the law, from as we know from the Vienna Convention, Vienna Convention on Law Treaties, and if you look at state practice, I think both of those would show that this type of organized crime is not meant to be part of what we consider armed conflict. But what I want to say is also, it's not that what I was arguing earlier is not that you need to exclude criminal activity. What I'm saying is I would exclude those situations where the group itself, I'm not leaving it to the state, where the group itself exhibits no political objective whatsoever and is trying to operate within the system for financial gain. So that's the argument I was making. Do you want to know whether I actually believe what I was arguing?
Sure.
Or shall we leave that to the end?
Well, maybe let's leave it. Let's leave it in suspense for
Maybe
another couple of minutes. Marco, agree or disagree? Does the question of political motive or its absence implicate questions of remaining true to the idea that we do not mix jus ad bellum and jus in bello?
I think there is also there is also a separation between jus ad bellum and jus in bello in non-international armed conflicts, and it is essential to separate the two. Obviously, you are right, it's not international law, but the same law must be applicable to the fight for legitimate causes and for illegitimate causes, because the victims of the situation need the same protection, and the law would never apply if the parties to an internal armed conflict have to agree on whether the cause for which the other one is fighting is legitimate or not. And I can assure you that, for instance, the government of Turkey is, with good argument, considering that PKK is purely criminal. And then I see that perhaps too much as a practitioner, how do you tell them, yes, but this is another kind of criminal. And today there's also, not the US, or on the contrary, the US has a tendency to overstate the law of armed, the idea that something is an armed conflict. But in other countries, they simply say, no, this is simply criminals. I mean, the Russian Federation with Chechnya, or in Thailand, the rebellion in the south. And so it would be very dangerous to start to say that certain causes exclude the applicability of the law of armed conflict. I should make now here a disclosure. because it's important. It was mentioned by Gabor that I'm chairing the board of Geneva Call, and I should clarify that Geneva Call is of the opinion that certain purely criminal groups are not armed groups, and we don't engage these groups. My hesitation with it is simply to say, and how do you define criminal? And this is a serious risk as soon as you open up to any exclusion of some people, and these are the victims, from the benefits of the law of armed conflict based on the causes for which a party is fighting.
Okay. And then, Marco, let me ask you one more borderline question, and then we'll open up to the audience. You said that there was this command structure element, and that while there are any number of parties involved in drugs in Mexico, some of them certainly meet the threshold of command structure that would be necessary to trigger the application of the law of armed conflict. But you said some of them don't. So if that threshold is crossed for, say, one organization, does that mean that all drug-related violence, both from the drug side and the government side, that occurs in Mexico is subject to the laws of armed conflict?
This is a general question of humanitarian law, because this can well happen in a traditional conflict where some groups, say Somalia, are fighting for a wonderful political cause, and there's also all kind of other violence. And I mean, in Afghanistan today, NATO and US forces have to distinguish between, and they do it, they try to do it, between the fighting against the Taliban and all kind of other violence which happens in the country, and hopefully they will use a law enforcement approach to it. So, I mean, if there is just a drug dealer in Mexico City who tries to, and anyway, I clearly distinguish between parties and the armed group of a party. And this is generally important in humanitarian law, and this is precisely what, for instance, Israel with Hamas neglects. That there is Hamas, which is the party, and then there's the armed group of the party. And obviously, it's often difficult to distinguish the two, but it is essential, because with the government you don't have the entire government which is the armed forces, but a government has armed forces. Obviously, this is more structural, but this is inherent in most armed conflicts other than the Spanish Civil War or Sri Lanka.
Noam, did you want to respond to that?
No, I'm actually ready to hear some
Okay.
questions.
Yes, sir.
So, my question involves the use of drones, because one of the things that occurred to me as you were talking is I thought about the case America used a drone to kill an American citizen in the end. And I was thinking, well, especially since the Mexican government in theory is working with us, likely, if there were an American citizen involved in the Zepa cartel, and the Mexican government said, look, we can't get him, but we know you have the technology that can, go ahead, do it for us. So wouldn't that make it a war? If it's a war in Yemen, why isn't it a war in Mexico if that kind of thing happens?
So, Noam, does the use of a drone attack make it armed conflict?
Where in general would the use of technology, drones, whatever, fit into this discussion that you're having?
Marco and I were just at a conference a few weeks ago in The Hague discussing the use of drones on global battlefields. But I think, to be honest, in this context, it's a bit of a red herring. I don't think that it makes a great deal of difference to the question that we're debating. If it is an armed conflict, then it's an armed conflict already before
No.
what you've said. And if it's not an armed conflict, then that doesn't make it an armed conflict. What I think is interesting here is the fact that a lot of the discussion that we've been having in this debate, if you just said terror instead of drugs,
Right.
Yeah.
That's part of it.
it would be very interesting, and a lot of Marco's arguments as presented in that position, and again he was arguing a particular position for the sake of the debate, so to be fair here, but if you would switch the two words and use those same arguments in the context of the so-called war on terror, it would end up supporting this notion of a global war on terror against all groups that are even vaguely linked under this label of terrorism. That's what those arguments would end up doing if we transposed them to the war on terror debate, and if that's what you're fine with, then okay. That's your view, but if you find it troubling in that context, then it's equally troubling to use those arguments in the context of this so-called war on drugs.
Marco, I think I know your answer to the question of whether that is red and whether it is a herring. But more specifically, does the use of certain technology or certain military means more generally, I think you addressed this already to some extent, not weigh in to the determination of whether or not the law of armed conflict applies, whether it's drones or tanks or something else?
In my view, it's the other way around. We have to distinguish causes and consequences. So, if the law of armed conflict applies, then the killing by drones, whether they are American or not, does not matter, is lawful of some people, while if it is not, then simply it is not lawful, and it's not because you violate the law that suddenly another branch of international law becomes applicable. So I agree with Noam that in addition, I would say that under human rights law, but this is not, unfortunately for Mexico, this is not the Mexican situation. Under human rights law, a government may never start a non-international armed conflict. It must always be the non-governmental side which starts, because the government must try to get over. If southern Manhattan is now controlled by insurgents, the government must say, we make a law enforcement operation. Everyone gives up their weapons and we take again control. But they cannot start with throwing missiles. It must be the insurgents who start to use violence which comes up to a level of armed conflict. And in Mexico, simply, it is the insurgents who started, and it's then the government who reacted with military means. Now, some people would say don't apply humanitarian law because it would justify the militarization. But the militarization is already there. And international humanitarian law applies according to the facts and not according to our dreams that it would be better if we were all making love instead of war.
Yes, sir.
Yeah, if the international community accepted Mr. Marco's position that the international laws of war apply against these criminal drug cartels, how would this apply to Mexico? Because the government of Mexico doesn't want this.
Yes.
And do you envision the United States intervening militarily in Mexico? I mean,
First of all, they already intervene because they support.
No, but I mean militarily.
Yeah. No, but there again I should clarify a misunderstanding that if it is an armed conflict, a non-international armed conflict remains an internal affair of that country. And it is not justified, this is clearly stated down in Protocol 2, but it's generally the fact that somewhere there is a non-international armed conflict, but I understand you, is not at all a possible justification for an outside intervention. But I understand you, because in plenty of countries, Pakistan, India, Thailand, Turkey, Russia, they deny that there is an armed conflict because they are obsessed by the fear that as soon as you recognize it's an armed conflict, you justify outside intervention. But this is simply wrong. Humanitarian law deals simply with the victims of armed conflict, and if it is a non-international armed conflict, this does not justify any outside intervention.
I'd perhaps add here that there's been perhaps to some extent a shift over the years in that governments, and traditionally you still see this sort of in the writings, you'll see, governments always prefer to say it's not an armed conflict. And some of the most famous cases are, Marco mentioned Southeast Turkey, PKK, but the UK and Northern Ireland is a perfect example of that. So this insistence, it's not an armed conflict, it's not an armed conflict. And usually that's for these political reasons, fearing that it gives some legitimacy to the armed groups, fearing that this shows that we've lost control. There are various almost psychological reasons that states may have preferred to say it's not an armed conflict. But we've also seen a bit of a change in recent years, particularly since 9/11. The US has seen this, and in Israel as well. Two good examples where the state has realized that there's an advantage to calling something an armed conflict, because it means we can have a looser finger on the trigger. Okay, we can apply this framework that allows for use of force, allows for direct recourse to lethal force. And if, for example, we said that was the case in Mexico, and this is an armed conflict, then we could have direct recourse to lethal force, targeted killings of people within the drug cartels. That's what we'd be saying can happen. Okay? And the difficulty here is who would be the people that we'd then be targeting, because Marco rightly said earlier, you have to recognize that when you have a group, there may be sort of the political wing. In this case, it'll be the business wing. Right? Again, this is where we have a big problem, but we'll have the business side of the operation, and we'll have the violence side, and it'll be the people involved in the violence that can be targeted. But the problem here, as I mentioned earlier, and this is why I think I do think it gets tricky, these tend to be the less organized of it, rather than the business side. But in theory, what would we end up saying? Any member of drug cartels who's walking around with a gun can immediately be targeted with lethal force. I mean, these are the implications, and this is one of the dangers here. And how do you operationalize that? And as I said earlier, also another difficulty is there might, and here we're starting to use our own views perhaps rather than the dogmatic black and white positions that we were asked to debate. In reality, maybe you can find one or two groups for whom the organizational threshold is met, and let's say even that the intensity is there, but it certainly doesn't cover all of the groups, and I think it probably doesn't cover the majority of the groups. So how do you operationalize this where you have, like I said, the person firing on us there, controlling the drug supply in that area, they're members of the Zetas. If they're Zetas, we can use these rules of engagement and use lethal force. But no, if they're the Sinaloa cartel, wait a minute, their people on the ground no, they're not as organized. We can't use lethal force over there. It doesn't work. So you're going to end up with a dangerous mess, and that's part of the difficulty, I think, as well. So again, sort of moving from theory into practice is a concern.
And I just want to make an observation from the rule book, which is that not all armed conflict that transcends national borders is necessarily international armed conflict. A non-international armed conflict is simply one that does not have two states on opposite sides. So if the U.S. intervenes into the armed conflict in a military way, assuming that it is armed conflict in Mexico, that doesn't make it an international armed conflict under the terms of IHL. It's still a non-international armed conflict because both states that are involved are on the same side of the equation. So it would still be the rules of IHL of non-international armed conflict apply, not the rules of international armed conflict. Yes, ma'am.
Thank you. I find your argument on the unworkability of the scheme quite convincing, but at the same time I'm wondering whether we aren't already in a situation where IHL faces such challenges
Yes.
on a daily basis. In a country like Somalia, where almost every civilian owns a gun, saying who's a civilian, who's a member of the fighters, whatever that may be, I mean, that's a whole other problematic category. And to say when is the civilian actually participating in the armed conflict or not, or joining the group but not joining it enough to be a target, that is a mess that we face all the time, and that is not sort of specific to drug-related conflict. So I'm just sort of wondering how you would address this.
Can I just ask that same question in another more specific way? John Brennan, who's I think about to become the CIA director, not long ago said that if you're a member of Al-Qaeda, we can target you. Does that concept of membership work in that kind of armed conflict as against Al-Qaeda? Does it work in a putative armed conflict in Mexico against drug lords?
I think in terms of the question you asked, and absolutely 100% yes, we have these problems in a lot of places, in most places nowadays where we have armed conflict, and it's also one of the biggest legal controversies in the area of IHL is the individual status. How do we determine who has lost civilian protection and who hasn't, and various, and those of you that are more familiar with the laws of armed conflict will be aware of the debates on what does direct participation in hostilities mean, the ICRC's new notion of continuous combat function and all of that. All I'm saying is, yes, we've got those problems in quite a few places. Let's not create them in even more places. All right. So if there are a few places where we can try and stay out of that mess, let's try and stay out of it rather than widen it and have these questions here as well, because it's enough of a problem in these places, and we already know that. So I agree with you, but I think that's one more reason to try and avoid getting into that over here. With regard to the membership approach, again here, who would be a member? And with Al Qaeda and the position that the US has taken many times, it's there's no separation between the political wing and the armed wing. It's you're a member of Al Qaeda, you're a member of Al Qaeda. That's it. But can we do that with the drug cartels? Can we separate between them? And by the way, if we're separating, then actually we mean that the kingpins, the big sharks, the ones that are really running the show. We said, oh, they're actually immune.
Yeah,
they're civilians. That's fine. But who are we going after? We're going after the people standing on the corners of the streets, controlling the turf. A teenager with a gun who's controlling that area of that neighborhood or that border. These are the members of the organized wings that we need to be now targeting with direct lethal force, which again, in terms of what we're trying to achieve here, I think ends up being counterproductive.
Marco, can we solve this with reference to the distinction between status and conduct?
Well, I would first of all say what he criticizes is inherent in the law of armed conflict. I mean, if there is an armed conflict against Iran, you may target the poor Iranian soldiers, but neither President Ahmadinejad nor the great ayatollahs nor
you have the generals and the high-level commanders that you can get to in Iran.
Yeah.
But here you won't be able to find them. You'll find the people up at the top, and you'll find the people on the streets, and we're going to have the problem with the middle. And I think that's the difference.
Okay, where do you define middle? I mean, in the Zetas there are commanders, but then indeed it's important to keep that away. And your question is the essential one, that everyone here assumes, apparently, but I know that this is not the opinion of Noam, that in non-international armed conflicts the same rules than in international armed conflicts apply, and therefore you may kill members of an armed group as if they were members of armed forces in an international armed conflict. I simply say, in international humanitarian law, I don't see such a rule, and therefore one could well argue that conduct-based, and I mean, when you come to conduct-based rule, which simply means the one who is directly participating in hostilities while he or she is directly participating in hostilities, the difference with the human rights approach is not so big.
Okay. Yes, sir.
I'm wondering, in regards to Noam's position, whether it would change if, let's say, for example, there was an agreement by the majority of the groups to form a coalition in Mexico, and if political causes sorts as well evolves, because I mean I think often in conflict there's enough changes that can radically change these kind of positions. And to give you an example of Colombia, right, we have a situation that began as a classic political armed conflict, and now the average Colombian may tell you that it's for the most part a criminal. Do they have a significant organization when the heads of their group have been killed? They're very isolated, they work very independently, they can't work. It's a political motive there. And then in cases like El Salvador, you have a situation where the Maras are, to an extent, have much more political inclinations, if you will. And there is a case where one could potentially argue that you have what began as a criminal organization is now has some sort of a political will. So I guess, can the status change, or does, is it just initially how is it as it began? Is that more or less you would see it, or would your position evolve? And then my last question was just in regards to the government, the position of the Mexican government. You guys didn't touch on that. Does that legally, how do they position themselves, and with that effect, how you would position whether IHL applies or not?
Noam?
Okay. Position of the Mexican government, I mean, it itself is, I think, in a process of change to a certain degree. Since the change of government, there seems to be a change also in operational policy. If the previous Mexican administration was sort of focused on taking out the kingpins, and trying to parade the ones that they've captured or killed, and except for those incidents in which the bodies of the people they killed get on themselves, then suddenly kidnapped and disappeared, which happened at least once. There are some changes, but they're not applying as much as they're using the military. They're not applying the law of armed conflict paradigm, and I think that is indicative. And there's a problem here, because we're not supposed to leave it up to the governments to decide whether something's an armed conflict or not. All right? The traditional position in the law of armed conflict is a government can't deny that something is an armed conflict if factually it meets the threshold. But again, here it's difficult for me, because whilst I recognize that that's the law and for good reason, but if you look at what the reason was because governments used to deny that it's an armed conflict in order to evade their responsibilities under the law of armed conflict and reduce the level of protection available to those that might gain from the laws of armed conflict. But if it's the other way round, if the government is actually insisting on applying a law enforcement framework which gives higher protection, and in the situation, I mean, in that type of situation, do we want to be turning around and saying, no, you should be targeting according to the rules of armed conflict rather than the rules of law enforcement? I mean, obviously not. I think the fact that they themselves don't use the law of armed conflict paradigm is important here. You mentioned the question of Colombia. One of the big differences, of course, there is the amount of power and the type of control that the FARC in particular have in Colombia, I mean, controlling 10-20% of the territory of a country, that's something very, very different. When effectively they are operating as a mini government of their own in a certain territory, it's I think very different to what we're seeing with regard to the drug cartels in Mexico. I think it'll be interesting to see what happens if the peace process in Colombia does go ahead, and if a large part of the FARC demobilize, but some people decide that they don't want to take part in the peace process, and they carry on purely for the drug-related activities. What will happen then, and what will the Colombian government do? Will the Colombian government continue also to consider it, at least part of it, as an armed conflict, or will they switch to a pure law enforcement paradigm, or not? And I think we can just sort of here wait and see what happens, but it could be interesting. Can the status change over time? Yes, it can. I mean, facts change, and when facts change, then our assessment of those facts and the laws that we apply accordingly will also change. I don't think it's realistic to think that all the drug cartels will unite under one banner and agree. They're too busy killing each other. I mean, most of the deaths in drug-related violence is inter-organizational violence. So that, that's not about to happen anytime soon. But obviously, had that happened, you would find what in theory could be a major power, and that would be different. It would also be a major power that we could then perhaps engage with differently. You can't engage. This is one of the difficulties, and Marco's well aware of this from all the important work that's done at Geneva Conventions, the organization you mentioned, which tries to engage with non-governmental organizations. One of the difficulties, I think, is you can't do that in this situation. We can say let's try, it's great, but I mean, do we really think that drug cartels will adhere to the laws? I mean, there are.
Who believes that Al Qaeda will adhere to the Geneva Conventions and additional protocols? But even the Taliban, if you read their code of conduct.
I've read the code of conduct. Yeah. It's an interesting one. There are here and there a few elements of who you can kill and who you can't kill, with some very light analogies to the law of armed conflict, but most of it's nowhere near. Yeah. We have a problem, but there's. I think inherently with the drug cartels, I mean, what are the reasons that organizations would adhere to the laws of armed conflict? To gain some kind of legitimacy? And you can make that argument with the Taliban, and there are people there, and there are attempts to talk to them, because they, at the end of the day, if you say, hey, you want to run this country, you're going to need some international legitimacy. Right? That's not going to work with the drug cartels. They're not even trying to run the country. They're not seeking, and they know they're never going to gain international legitimacy and that kind of support. So you can't even make those arguments with them. You also can't make the arguments based on reciprocity. They're never going to get that kind of reciprocity from the state. The value-based arguments, I mean, none of the arguments that we use traditionally and that we can use and try to use with the Taliban, for example, they're not going to work here. So even if you had sort of someone you could talk to, I'm not sure that there's anything to talk about.
Rick, you had a question?
Yeah, I don't usually ask questions, but what got me thinking, you mentioned the process of peace processes to resolve non-international armed conflicts. And I think it gets down to the question of objective that you both talked about, whether it's relevant or not. Because obviously within the international sphere, when you have a non-international armed conflict, something that's recognized as such, the immediate response from the international community is to press for a ceasefire and some sort of peace process, peace negotiations, which typically when you have a political objective of a rebel group, those negotiations happen along maybe disputed territory or democratic participation, minority rights, whatever those might be, but in some way to usually negotiate towards fulfilling human rights obligations of the state. In the context of something where we're looking at drug cartels, how does that negotiation take place? Because the only place for the state to negotiate would actually be to violate its obligations under the drug conventions. So presumably in a situation like Mexico, if you're not looking for participation in government, you're not looking for, to resolve pre-colonial boundaries or those sorts of things. If you're simply a profit-making enterprise that works in this particular sphere of criminal activity, what's your negotiating point? How do you have a peace process? It's strictly a zero-sum game, it seems.
Marco, you hit that.
This is the tragedy of the Democratic Republic of Congo and of the reaction of the international community towards the Democratic Republic of Congo, where the international community and especially all these peace negotiators and so on say, you have to make a deal. And the deal is you have to integrate the armed forces of the rebels, which many are purely criminal, into your governmental armed forces, and this perpetuates the conflict. But it's not a sufficient reason to say there's no armed conflict in the Democratic Republic of Congo. It comes and comes again, and probably the idea of not the serious people who make research into peace, but diplomats, they simply want to have a deal. And diplomats would certainly find a deal in Mexico. But I agree with you that this is not the solution, and humanitarian law does not say somehow you must make a deal with rebels. Some rebels have to be fought until they are defeated, but while you fight you have to comply with the rules applicable to such fighting. And there my problem is simply when you said the Mexican government, why should we discourage the Mexican government to comply with human rights law? It may. No one prohibits them to do that. The reality is simply that there are a lot of summary executions, including of people who could not be targeted under the laws of war. And this is a general phenomenon that when you deny that there is an armed conflict and you apply unrealistic human rights law rules to an armed conflict, armed forces lose their patience. When they see that people they arrest, enemies they arrest, are systematically released by judges, not because they are corrupt, but simply because there's not enough evidence. And often there will not be enough evidence. The next step is that they kill people when they arrest them, or this is, to my knowledge, not a problem in Mexico but elsewhere, secret detention, because those who fight don't tolerate such a situation. I must say in Colombia, precisely on what you were mentioning, the difficulty to distinguish, in Colombia the armed forces have a red card and a blue card, and they are told this operation is blue card, law enforcement, this operation is red card, conduct of hostilities. I don't want to say Colombia is an example for the respect of humanitarian law, but nevertheless, I mean, it is something to which even governments confronted to genuine armed conflicts have to find an answer, and the correct answer is not as soon as there's an armed conflict you target everyone, but you have to distinguish.
So I think we have to wrap up in a couple of minutes. Noam, and I don't know if we have time for another question, but we'll see.
Just very quickly then, I agree with what Marco said about the relevance of peace process or not. On Colombia, by the way, though, yes, they have a red card and a blue card, but the red card, which is the conduct of hostilities one, actually still has a preference for capture over kill.
No.
So even in the red one, the so-called conduct of hostilities one, they're still using something which has some affinity to the law enforcement approach rather than to.
So I hope the Mexicans would do that.
So I'm just saying that's worth mentioning, because even when we use that example, actually they're still trying to operate within the law enforcement. And well, I'll leave it with that so we have time for more.
Rick, has the clock run out on us, or do we? Okay, maybe we have a little bit more time. Yes, ma'am, back there.
And I just wanted to add something. I share Mr. position and add on that on the applicability of the humanitarian law on organized crime. way to define crime. A crime is defined. Crime is defined in convention. So it's not up to the government to define crime. We have an international convention on international crime, and we have the law of the convention. So we have a definition there. And that it is going to be faced with law enforcement. So it is very clear on that. And I think that will be, when you said that it is about the legitimate protest, and legitimate protest, it's not that. It is defined. It's defined crime, and there is a way how the international community has agreed to fight crime.
Okay.
But
Go ahead.
just a point, by definition, a non-international armed conflict, it consists of crimes. If I start to use violence against the US government in the US, this is a crime. And now you will say, yes, but here it has been designed by international law. Well, terrorism, not fully defined, but a lot of aspects of terrorism have been defined by international law, but I am convinced that the mere fact that an armed group uses terrorist means does not mean, which are prohibited by international law, and there are international conventions against that, but that doesn't mean that it's not an armed conflict.
Right.
Even if I wouldn't share all the US positions, this one seems to me acceptable.
And I think maybe we'll take one last question. Yes, ma'am.
Oh, okay. This is slightly tangential, and I apologize, but it's short. There's been this wave of whispers about legalization throughout the region, and with the intention of decreasing the armed conflict related to drug violence. And would that therefore even further Noam's argument that if legalization will lower the violence, that therefore is even less harm-wise, even less applicable? And what are your general feelings about what consequences legalization could have on this paradigm that we're talking about?
I was wondering how we're going to manage to get through a whole evening on human rights and drug policy without the question of legalization, and then it's the last question. Without, because again, it's not the main issue here. Without getting into the whole debate of whether it's positive or not, if factually legalization happens, and factually that means that we see a lot less violence, then clearly we will be moving even further away from any possible discussion of is this an armed conflict. But I mean, that's just sort of the direct implications that may happen. Will we see legalization? Will legalization lead to reduction in violence? That's a big one, but can't answer that.
Marco, any observations?
No,
on
well,
that?
this is for every armed conflict, so we hope that non-international armed conflicts will end. Also in the US, you must say George Washington, we hope that it doesn't end before he wins. But, and purely technically, just a reservation to what you said, at least according to the jurisprudence, once it is an armed conflict, if the intensity decreases under the threshold, under the Yugoslavia Tribunal jurisprudence, it says until a peaceful settlement it continues to apply, but this may be wrong.
Yeah, we had quite a few debates on that a few months ago on when does it end.
Yeah.
Let me also suggest that legalization doesn't mean the end to, say, competition between cartels and violations of the laws of regulation and hostilities as a result of all that, and criminal activity as a result of that, and a state's potential even continued military response to all that. I think we've pretty much come to the end of the patience of the sandwiches. They want to be eaten. So I'm not going to close, but I do want to thank you all and thank the participants very much, and then turn it back over to you, Rick, for some closing remarks.
Yeah, just very quickly, because I know everyone's been sitting a long time, I'd really like to thank our panel. I think you'll all agree with me that this was a fascinating discussion, and both our two panelists and our moderator, I think we couldn't have asked for a higher degree of expertise and detail in teasing out some of these issues. As I say, IHL is not my particular area of specialty at all, which is why I asked the question. It's a very fascinating discussion. I'd really like you all to join me in giving them a warm round of applause and thanking them. And once again, I'd like to thank you all for coming tonight. It's a fantastic turnout, and I hope really speaks to growing interest in this area of drug policy and human rights that our center has been trying to promote. I would encourage you to visit our website, which is humanrightsanddrugs.org. Among the debate series, we also produce the only peer-reviewed law journal looking at issues of human rights and drug policy. We also do various lectures around the world and try to really encourage students of law and students of human rights, postgraduate students, to really try to engage with some of these issues in your own work, because I think once you start to look at issues of drug policy, you'll see that there's so many cross-cutting issues where drug policy, drug enforcement intersect with various issues of human rights or humanitarian law. And you'll also find that the vast majority of those issues are very, very under-researched. So it's actually not only an interesting area of law and human rights, it's also an area where you, as students and as researchers, can actually make a really strong and unique contribution to this area, because so much of it really has not been written about at all. So it's really a really ripe area for further discussion and further academic research across the board. I'd like again to thank the Human Rights Institute at Columbia for hosting us. I'd like to thank Human Rights Center at the University of Essex. I'd like to thank the Open Society Foundation's Youth Initiative for funding us for this wonderful thing. And I'd like to invite you all to join us for a glass of wine or a soft drink or a sandwich, and feel free to discuss more with our panelists. Thank you very much.